So the title of my presentation this morning is what every business owner should know about the law. And over the years as a business lawyer, every now and then I come across a little nugget of business knowledge or law knowledge that's surprising to me. And I think, I'll bet business owners should know this. But I'll bet they don't because it's not intuitive and you just wouldn't know it if you didn't learn it. So I've collected a few of those nuggets and that's what I'm going to introduce you to this morning. So first of all, we're going to talk about your website. Do you own your own website? Now, when you hire a web developer, someone sits, or in this case stands, at his desk. He's a modern man, obviously. He's got a stand-up desk. Although you've got to always, wonder about someone who types on a computer that looks like a Macintosh, original Macintosh. So I don't know if I'd trust a web developer that had a monitor like this. So someone's actually typing the code that is going to be your website. And as this person types along, copyrightable material is created. But who owns the copyright in this material? You would assume, since you paid this person to do it, you're buying the website and that you would own it, but that's not necessarily the case. So the general rule is that the author or the creator of copyrightable material owns the copyright in that work product as it's created. So that's the general rule, but there's a couple of exceptions that are important for us when we're thinking about our website and whether we own it. The first one is the work made for hire exception, and then the other is assignment. So let's talk about works made for hire initially. The first one is employees, and this one's pretty straightforward. If someone's employee creates copyrightable work product in the course and the scope of their employment, the employer owns the copyright in that work product. So if your web developer is your employer or your employee, you're in good shape from the beginning because you're going to own it, no problem. The other 9 categories, though, aren't that straightforward. And for our website purposes, it's even more concerning because if you look at these various categories, assuming you can read my writing, you'll see that your website code probably doesn't fall into any of these categories, so it's probably not going to be a work for hire. So contribution to collective work, part of a motion picture or other audiovisual work, translation, supplementary work, compilation, instructional test, or test answers, or atlas. I mean, none of that sounds to me like code for a website. So the work made for hire may not do the trick. So you've got this developer typing away, creating copyright in your website. Are you going to own it or not? So the little office tower is, your company. It's obviously a successful company because, you're in an office tower. So, so the little circle C, of course, is copyright. And so if the web developer is your employee, you own the copyright, no problem. But what if the web developer isn't your employee? So the copyright initially vests in that person typing away, and we get it over to your company by transferring it, and that's where your contract comes in with your web developer. So there's 2 important provisions that you want to have in your contract with your web developer. One is a work made for hire provision, and then the other, since the copyrightable material that they're creating probably isn't going to qualify as a work made for hire, you want to have an assignment provision. So I brought my legalese with me, like any self-respecting lawyer would do. So here's some language that could be in your contract that can help you with this. The creator hereby assigns to the company all work product. And I know, creator, you can think about it more than one way. I like to think of, as God created the heavens and the earth type thing. Give the artist a little, make them feel good about themselves. So, because they're about to sign away their contract or their copyright. So hereby assigns. That's very important language, and it should always be in your assignment clause. Hereby assigns. Now, when you sign your contract for your website, none of this copyrightable material exists yet, and so it's all going to be created in the future. And so, in a lot of contracts, you'll see language like this down here agrees to assign, and that's just not sufficient. There was a Supreme Court case just a few years ago that was a really significant case, and it showed definitively that this language isn't sufficient. So you need to have a present assignment of future work product that's going to be created in the future. So now we're going to add a third party in here, because you're probably not contracting directly with the individual who is actually typing the code for your website. So here we've got you still in your office tower. We've got the more modern, sleek web development company in the smaller building, and then of course we've got the person actually doing the typing and creating the code for your website. So you, of course, are going to have a great contract with your web development company, because now you need a work for hire clause in there, you need an assignment clause in there that has hereby assigns. But the web development company can only transfer copyright to you if it has copyright. So how do we know that the web development company has a good contract with any freelancers or any independent contractors that they have hired? So it's important for them to have agreements with any non-employees that are going to be working on your project. I mean, the most obvious and probably best thing to do is ask your web development company to see its contracts with its independent contractors and freelancers, although most companies probably wouldn't cough that up for you. But we need to make sure that the copyright actually goes from the person doing the typing to the web development company to you. And here's the strategy that I use in most of my agreements, and that's to require the web development company to only use either employees or independent contractors or freelancers that they have an adequate contract with. So if you're dealing with just a sole proprietor, this language here could work. All services will be provided by the creator. That's the sole proprietor that's actually you're contracting with, who's doing the typing. If you're dealing with the company, you'll probably want something more like this, that the services will only be provided by employees of the creator or by employees and independent contractors who have an adequate contract. And I've been talking about website, but these principles apply anytime any kind of copyrightable work product is created that you commission. So if you hire someone to put a logo together for you, or a marketing brochure, or any kind of marketing copy, or anything that is copyrightable, these principles apply. So make sure that you own your website. And I've talked a little bit about some legal language, and I put, in order to give you an example of it, I put a sample contract on a site called Docracy. And so you can go find that contract. So go to docracy.com, D-O-C-R-A-C-Y, and then just search for Creative Services Agreement. And the one that I put up there will be the top one. So, copyright. Are we all woke up yet? Really talking the law here. So in keeping with the intellectual property theme, the next little nugget that I want to talk about involves trade secrets. Don't destroy your trade secrets. I had a little bit of trouble trying to figure out how to visualize what a trade secret is. My wife suggested a safe, because that's one of the most important things is to keep your trade secrets safe. In fact, the most famous trade secret probably is Coke's recipe that they do keep in, part of it in one safe, part of it in another. No human knows the whole recipe. So they're very careful about keeping their trade secrets sacred. So what's a trade secret? It's information that has economic value because it's secret. And also, the other real important part to it is the owner of the trade secret uses reasonable efforts to keep it secret. So we want to make sure when you have a trade secret that you always use reasonable efforts to keep it secret. Now, it's really common in business for businesses to exchange confidential information. Sometimes that information includes trade secrets. And so, usually you'll sign a non-disclosure agreement so the recipient agrees to keep your information safe and secret. But there's often a clause in there that I think of as the period of protection. And so it'll basically require the recipient to keep the information secret for maybe 3 years. And that makes sense for a lot of business information that might go stale, but if you're going to disclose trade secret information, you can't do it under a non-disclosure agreement that only protects it for a limited period of time, but because courts have held that that's not using reasonable efforts to keep your trade secret secret, so you could destroy your trade secret. So you want to make sure that you've got some good legal language to protect you in your non-disclosure agreements if you're going to disclose trade secrets that requires the other party to protect it indefinitely, or, I mean, I like this phrase, the end of time. Yeah, I guess after that it doesn't matter. So, can anyone spot the typo? See, that's a trick question. How can you have a typo? Is it a righto? Or I could bring out the legal term, it's a scrivener's error. So, obviously I didn't see that until after I unleashed this on the world, so, yeah. Last practice, oh, I've got a typo, how'd that happen? Okay, so my third topic, little nugget, watch out for boilerplate language. What's boilerplate? It's that fine print, those contract terms in the back of your contract that are very standardized, that are very highly negotiated in every contract that everyone reads, right? No, they're those contract terms in the back that no one ever reads, and you don't pay attention to them because they're all the same and they don't mean anything. That's not always the case. These boilerplate terms can be real important, and they can affect your legal rights significantly. So here's a nice little example. We've got this is from a real life case. I blogged about the case in 2011. I think it took it a while to get through the courts, but the facts of the case actually occurred in 2001. So this company engaged a cruise line to charter a ship, and this was in the spring of 2001, and they had the foresight to negotiate with the cruise line a letter that stated that in the event of terrorism or something that made it impractical to do the trip as scheduled, that they'd be able to get their sizable deposit back. And so they got this letter from the company. They later signed a contract, and 3 weeks before the cruise was scheduled, 9/11 happened. The State Department issued a statement warning people not to travel abroad, so this company's employees and other guests who were going to be on this cruise started canceling, and so the company contacted the cruise liner wanting their money back, and the cruise liner refused. And they based the refusal on a little piece of boilerplate in their contract. And the clause was what we refer to as an entire agreement clause or an integration clause. And these provisions are really handy. What they do is they basically say that the words in the contract contain our entire agreement, and no other negotiations, no other documents or whatever that have been a part of the negotiations are applicable anymore, but they're all superseded by the contract. And that's a really good, handy provision to have in your contracts usually, because what it does is it keeps someone from later coming up with an email during your negotiations and saying, well, you breached this part of the contract. And then you've got to bring all this extra, you've got to prove that that wasn't part of the agreement, and it just would raise the cost of litigation whenever you do, whenever your contract went to court. So these are helpful provisions, but unfortunately, the court sided with the cruise line, and so even though this company had a letter from the cruise liner saying they could get their money back, that letter just went away when they signed their contract with this language in it. So and I've had this come up in my own practice in contracts where you have an earlier agreement in writing, and then later, and you negotiate something that's real important, and then later you sign a contract that has an integration clause, and that earlier agreement will just go away if you don't carve it out of that clause or deal with it in some way. So be careful about your boilerplate. So my last little nugget has to do with avoiding personal liability. And there's a concept called piercing the corporate veil. And people do business a lot of times through an LLC or a corporation because they want to protect their personal assets against the liabilities of their business. So, someone slips and falls in your store, they're going to sue your company, but they won't be able to get your personal assets and sue you too. That's the concept. They call it a corporate veil. I kind of hesitate to go to the next slide because I really had trouble figuring out how to do this one. That's my veil wrapped around my building. So, but anyway, so now that's been unleashed on the world. Hopefully this video will be one that doesn't get out to the public. Yeah. So sometimes a court will pierce the veil. So we've got our little arrow. I couldn't draw a spear. I gave up after 10 tries, so just, there's an arrow. So sometimes a court will pierce the corporate veil because of the circumstances, and they'll hold, I'm out of time. They'll hold the owner of the company responsible for that. And I've known about that for years. I mean, it's a very well-known concept. I'm sure it's not new to you. But I came across a case a couple of years ago that really surprised me. I've been encouraging people to be careful about how they sign their contracts for years and not to sign as owner. And so, that's often a problem. And I've also, for years, have, advised people when they sign or file a fictitious name registration with the state of Missouri to make sure that their company is listed as the owner and not themselves individually. In this case I came across a couple of years ago, the court basically held the business owner responsible because they did these two things wrong. They signed a contract under the fictitious name and as owner, and the court said, well, this shows that you're doing business as a sole proprietorship and not through your LLC, and so you're going to be responsible. So make sure your company is listed as the owner in your fictitious name registration, and then don't sign contracts as owners. You can see this sample or signature block, and you don't want to be owner, but my title is manager because I have a manager-managed LLC. So those are some nuggets that I have come across through the years, share them with you, and now I will open up to questions. Yes?
What if you use a service like Upwork, the online virtual contracting firm, to do copywriting and things like that? I have to admit, I've hired but never read all the paperwork, the legalese about using that.
Yeah, that's an interesting question because now you're talking about website terms of use that nobody reads at all, right? It's the same principle though. I mean, if the contract doesn't assign copyright to you, then you're just not going to have the copyright. So.
Brian, on that last tidbit, with respect to, yes, signing as manager rather than owner, is that not just a technicality? I mean, would you not really ultimately be held accountable as the owner? I mean, I'm not sure I get that.
No, it's not at all a technicality because with the corporate shield in place, the party of that contract is your company and not you personally. And so unless you guarantee that contract, if the company breaches or there's some liability under the contract, the party to the contract is your company and not you, so you're not going to be held responsible. So apart from this breaching the corporate or piercing the corporate veil issue, now I will say this case was a little bit odd. For one thing, they assess punitive damages, which you usually don't see in contracts. That's something you'll see in a tort, trespass or assault or something like that, but contracts usually don't have. I think the judge was kind of upset at this fact pattern here, so. Or maybe they had a good lawyer, I don't know. The plaintiff was a law firm, so maybe that was the problem. So, anybody else?
Brian, we were always trained when we're doing work like with legal work or agreements that it was to our advantage to be the one who actually put the agreement together rather than the other party. Mm-hmm. Is there any truth to that, or was that just brainwashing that we had?
No, that's true. I mean, definitely. Okay. Whenever you draft anything, there are a number of drafting decisions that you have to make. And when you are drafting the language yourself, you can make those decisions, sometimes in subtle ways in your favor, sometimes in not subtle ways in your favor, but it's almost always better if you can do the drafting yourself. The only downside is you have to pay someone, I mean, sometimes it's more expensive to do it that way, but it does give you an advantage in the negotiations. Anybody else? Okay, thank you very much.